Hello and welcome to another Cunningham Legal webinar. I am your host, Daniel G. Van Slyke, one of the attorneys here at Cunningham Legal. And today we will be discussing the topic of remarriage and blended families, critical estate planning issues. Before we do, we start, as usual, with our disclaimer. And that is that although I am an attorney and although I am discussing legal topics, this is not legal advice. This is an informational webinar only. I do not know your specific situation and I cannot speak to it directly. My name again is Daniel Van Slyke. I am one of the estate planning attorneys here at Cunningham Legal. I have a number of years of experience in probate and trust litigation, and then I decided that I would feel better helping people to avoid probate and trust litigation, and so I came over to the realm of estate planning. I have my JD, my law degree from Texas A&M University School of Law, magna cum laude, and I am licensed in California, Texas, and Missouri. Yes, I did take 3 bar exams. I also interned at the Second Court of Appeals in Fort Worth, Texas, a very eye-opening experience when it comes to understanding law. Subscribe to our YouTube channel. We have a number of webinars there, which are very informative in various areas concerning estate planning, trusts administration, and related topics. Here is our team of attorneys. We have now 8 attorneys at the firm. We are located both in Northern and in Southern California at a variety of offices. We appear very frequently with our clients via Zoom and telephone, so we work remotely as well, and I even prepare Texas trusts remotely for those of you who are living in the great state of Texas. If you would like to make an appointment with us, you can visit our website. And right up there at the top, you see request appointment. Click that button and we will be happy to see you. Let's start with the impact of remarriage in the United States. And this is based on 27 statistics. Statistics are statistics, but this is what we have. About 29% of all marriages in the United States involve at least one person who has been previously married. And that can be to a spouse who has died, or the marriage may have ended through divorce. So remarriage after bereavement or after the death of a spouse, that is 5% of women and 12% of bereaved men remarry after the death of a spouse. So men are definitely more likely to remarry after the spouse dies. Remarriage after divorce, around 70% of people who get a divorce marry again. That's almost 3 out of every 4 divorced people will marry again. And the median amount of time it takes for someone to marry again is 3.7 years after a divorce. Experience with divorce was of the belief that if you got divorced, you didn't believe in marriage or you didn't want to be married. In fact, that's not necessarily the case. You may recall this scene from the Alfred Hitchcock film, North by Northwest, one of my favorites, in which there is a proposal made by the hero to the heroine while they are clinging by their fingertips from Mount Rushmore. And the question is, after the proposal, I don't want to marry a man like you. Why? What's wrong with a man like me? Well, they don't believe in marriage. I've been married twice. So he wants to marry again. That's going to be his 3rd marriage at the end of this movie. Now, remarriage with children, about 80% of couples in a second or subsequent marriage have at least one child from a prior relationship. Some of you may recall the show, I believe it ran from 1969 to 1974 or 5, The Brady Bunch, where the mother of the family came to the family with 3 girls and the father came with 3 boys. And much of the show was about their growing pains and learning to live together as a blended family. Critical estate planning issues arise with blended families. If you die without updating or creating an estate plan, your legacy likely will not pass according to your wishes. So you have to ask yourself certain questions and don't assume that doing nothing will make the answers you give happen. So do you want your new spouse to inherit your assets? You may or you may not. Do you want to provide for your spouse if you die first? Do you want your children to inherit your assets? How about your children from previous unions or marriages? What about your children with your current spouse? How does everyone get along? Do the children get along with each other from both sides of the family? Do the children get along with the parents? Do the stepchildren get along with the parents? Who will receive what if you do not revisit your estate plan? The answer may surprise you, and we'll look at that in a moment. And who will make your healthcare decisions? That's another issue that we will always address when we are creating estate plans for blended families. Do you want your spouse to make the decisions, or do you want your children to make the decisions? Let's first review briefly the impact of divorce on your estate plan. I'm not going to go into too much detail because we have another webinar coming up that will discuss this topic in more detail with my colleagues, Winston and Jim. So the impact of divorce on your estate plan. Divorce does change your existing estate plan, whether you want it to or not. And by the way, whether you have one or not, the state will provide one for you and divorce will change it. So let's look briefly at the impact of divorce on estate planning. In California, if you have a will, and in that will you left something to your ex-spouse, divorce revokes all those bequests, all the gifts that you made to your spouse in your will. It's all wiped out, as if your spouse didn't exist in your will, but only after the divorce is final. So that's in California. Not every state has a law like this. So your laws may differ depending on where you live. There are two things that are very particular to each state. Well, there are more than that, but for our purposes, when it comes to law, family law and estate probate type laws, those are different from one state to the next. Now, only after the divorce is final does the will get revoked, any bequests giving anything to your ex-spouse. Trusts also are impacted during divorce. Living trusts are often dissolved. The order or the final decree of divorce will often dissolve it explicitly, or divorce could automatically revoke the trust, but that's not necessarily the case. Again, it depends on your state law and the terms of your divorce orders and of your estate plan. While divorce is pending, your soon-to-be ex-spouse remains an heir or beneficiary of your estate. So in the first example, Hank signed a will, leaving everything to his wife, Willow. Hank files for divorce, but does not change his will. Before any divorce orders are entered by the divorce court, the family court, Hank dies in a car accident. Willa inherits everything. And she didn't even have to pay her family law lawyer anymore. So that's a win for Willa, but definitely not what Hank intended. In a second example, let's say that the divorce is finalized before Hank dies, even though he never changed his will. Well, in that case, Willa inherits nothing. So if you file for divorce or your spouse files for divorce and you have a will leaving everything to your spouse, you might want to revoke that. Non-probate assets are also part of your estate plan. Now, what do we mean by non-probate assets? These are the things that don't pass according to your will or your trust. For example, retirement accounts, your IRAs, your 401ks, these do not pass according to your will or trust. Life insurance policies, bank accounts with payable on death type of designations. They do not go through your will or through your estate in general. There are some exceptions that we sometimes use. But some states will revoke non-probate beneficiary designations at divorce. For example, in Texas and California, If you have a bank account with a payable on death designation and you have it going to your ex-spouse at your death, that money in that bank account, it will automatically be revoked upon divorce. So it won't go that way. Now, which way will it go? You're going to have to revisit that, but it won't go to the ex-wife. On the other hand, California's law does not apply to life insurance. So think of that. If you forget to change the beneficiary of your life insurance, all that money could go to your ex. These state laws do not apply to federally regulated accounts, including 401k retirement plans. So if you don't change your beneficiary designations on those, and you leave your ex-wife or your ex-husband on there, then that ex-spouse is going to get that money. So that's another unintended consequence of ignoring your estate plan after a divorce. Now let's look at the impact of remarriage on your estate plan. Like divorce, remarriage changes your existing estate plan, whether you want it to or not, and indeed whether you have one or not. If you don't have one, it changes the state's idea of your plan. So under California law, a marriage automatically invalidates any pre-existing will or trust as to the new spouse's inheritance rights, unless the documents provide for a new spouse. So if you have a trust or a will that you signed before you married again, and that trust or will doesn't mention your current spouse, then your current spouse will receive what's called an intestate share. That is what the state believes your spouse should receive. If your will or trust does not mention that spouse, your new spouse will receive that share. And again, what is that share? It depends on the state in which you live. We'll look at it right now. In California, the deceased spouse's community property assets are distributed to the surviving spouse. And then the deceased spouse's separate property is distributed to the surviving spouse and to the children. So this is without an estate plan. And we're going to look in a moment a little bit more at the distinction between community property and separate property, because you may be asking yourselves, Daniel, what is the difference between community property and separate property? I'm going to address that in a moment. But just so you know, they don't necessarily go the way you think they go. So let's look at community property, and then we'll revisit that slide. Community property is a characterization of assets as belonging either to the community, that is the marital community, kind of the community formed by husband and wife, by spouses, or separate property matters, especially at death. There are really three times when the distinction between community property and separate property matters. They all begin with D too, by the way. Death, divorce, and debt. So it matters in debt collection. That's not our topic. Matters in divorce. That's only ancillary to our topic. Above all, it matters at death. So what is separate property? In some places, it's called sole or non-marital property. In general, it is property that you acquire before your marriage, that was inherited during the marriage, or that is gifted to one spouse during the marriage. So acquired during the marriage, say you bought your home before you married your current spouse. That home is your separate property when you go into the marriage. Inherited during the marriage, let's say that your parents die while you're married, and then you receive their house. Well, that house is separate property. Now, community property, by contrast, also known as marital property, is acquired by either spouse during the marriage. So that includes, for example, income. You're working, you're earning a wage. In community property states, that's community property. It belongs to the marital community. And sometimes when you mix community property with separate property, it becomes community property. So watch out for that. Your family law attorney can certainly tell you much more about that, and we can discuss it in further detail as well. If you look at community property states, that's not the majority of states in the union, but it does include California and Texas, if you see there. It's these light blue states, and wouldn't you know, California and Texas have something in common. They are both community property states, but the way community property is handled differs between them. So let me go back now to that intestate distribution of your estate in California. So if you die, again, if you die without a will, or if your will's been, let's say you die without a will, without a trust, here's what happens. Community property, those assets are distributed to the surviving spouse. So this is in California. Community property that, let's say you bought a house while you were married, that goes to your surviving spouse. Separate property is treated differently. So the deceased spouse's separate property is distributed to the surviving spouse and to the children. And it goes in California, the spouse gets 1/2 if the deceased spouse has only one child. If the deceased spouse has more than one child, then the surviving spouse gets 1/3 of the separate property. Again, that's probably not what most people intend, but this is what the state does if you don't plan. Intestacy laws do differ from state to state. So if you have property in another state, that state's laws likely will govern how your property there will pass in the absence of a good, solid estate plan. Remarriage, by the way, does not invalidate an existing will or trust in Texas, unlike in California. So here's an example. Harry signed a will in 2000, leaving everything to his mother. Harry loves his mama. Harry married Wanda in 2010, but never changed his will. He loves Wanda too, but he just forgot about the will. When Harry died in 2020, Harry's mother received all of Harry's separate property and Harry's half of the community property because that will was still valid, not automatically revoked by marriage in Texas. Now, let's look at Texas intestacy laws. What happens if you do not have an estate plan and you die after a marriage in Texas? Do not have a state plan. If you do not have a plan, 100% of the deceased spouse's community property assets are distributed to the surviving spouse, unless the deceased spouse had children with another person. So if the deceased spouse had children from another union, then only 50% of community property goes to the surviving spouse. The deceased spouse's separate property is, on the other hand, treated differently. And this is a difference between California and Texas. In Texas, separate property is divided between real and personal property. So the real property, the surviving spouse gets a life estate and a 1/3 interest, and the rest of it goes to the children. What does that mean, a life estate and a 1/3 interest? It's a strange concept, but it means that the surviving spouse basically has the right to use, occupy real property of the deceased spouse as long as the surviving spouse lives. After that, all of that real property, that separate property of the deceased spouse, goes to the children of the deceased spouse. Personal property, on the other hand, jewelry, clothing, furniture, heirlooms, motorcycles, 1/3 goes to the surviving spouse, 2/3 goes to the children. Now, again, you're living in Texas, ask yourself, is that what I want when I pass? I'm in a blended family, I've remarried, I have another wife, I have children from a different, from a previous union. Is that what I want? Chances are it is not. So you need an estate plan. So mistakes, estate planning mistakes to avoid upon remarriage. First of all, not changing your will or trust. Let's give an example of how this works out. In 2010, Hale prepared a trust, leaving his estate to his daughter. In 2015, Hale married Wanda. Hale and Wanda purchased a home together in 2016 and put all their money in jointly held accounts. So what are you hearing here? That's community property. They purchased it together, they mingled all their money, it's all going together. So it's community property. Hale always intended to provide for his daughter when he died, but he never updated his trust. So when Hale died in 2020, I'm presuming here that Hale lives in California, by the way. When Hale died in 2020, Hale inherited all of Hale's community property. I mean, Wanda inherited all of Hale's community property, which was basically his entire estate. Hale's daughter received nothing. Probably not Hale's intention, but he didn't update his estate plan. So the daughter is out of luck. Not preparing a will or trust is another example of a planning mistake that you should avoid after remarriage. So let's look at this one. Hugh had 2 children from his first wife, and he divorced that first wife in 2000. Hugh purchased a home in 2002 in Pasadena, California. Hugh married his second wife, Harriet, in 2005 when they were 55 years old, and they moved into Hugh's home. So what are you hearing here? Hugh's home is separate property. I know you probably are not reading this the way lawyers read it. That's why I'm interpreting it for you. Hugh's home is separate property. He purchased it before the marriage. Okay, that is the marriage to his second wife, Harriet. Hugh never prepared an estate plan, but he wanted Harriet to keep the home when he passed. He just assumed that would happen. Sorry, Hugh, that's not the way it goes. When Hugh died in 2020, his children inherited 2/3 of the house, Hugh's separate property, and Harriet inherited 1/3. Hugh's children never liked Harriet, and they tried to force her to sell the home. Harriet does have an option for keeping the home, but it means that at the age of 70, she has to go to probate court and she has to seek an order allowing her to live in the home. It's what we call a homestead right, but you have to actually go to the court. And this could wind up dragging out and being a battle for poor Harriet. Oh, Hugh should have planned. Hugh should have planned. Another estate planning mistake to avoid is not changing everything with a beneficiary designation. These are what we call non-probate assets. Again, that includes retirement accounts, life insurance policies, bank accounts that are payable on death, or investment accounts that transfer on death, and even sometimes transfer on death deeds. You may have one of those as well in your real property. If you do not change those upon remarrying, there's a good chance that your spouse at your death will not receive these things because you didn't ever change the beneficiary designations. Now let's take a step back and let's consider some blended family dynamics, because when we're going to prepare an estate plan, we want to get to know you, we want to get to know your family. Because the more we know about your family and we learn about your goals, the better we're able to tailor a plan that meets your needs. So you have a blended family. What kind of blended family is it? Let's look at some of the options or some of the possibilities. Blended family dynamics. So are you sure we're doing the right thing? If you've ever seen this movie, Yours, Mine, and Ours, these are different characters with a very different set of children. And the children themselves are undermining the relationship between the parents. So this is a situation where you have a blended family with children, minor children, still living under your roof. And it can be rough. So remarriage can bring great uncertainties. Indeed, some blended families, as in this film, have difficult times, and at times it doesn't look like the relationship's going to last. And the effort of children to undermine the relationships is actually a rather common motif. Might recall the Doritos commercial. You keep your hands off my mama, you keep your hands off my Doritos. 2 rules in this house. On the other hand, you can have children living under the roof and have a very harmonious relationship, which might be a little more likely when there are not other parents hanging out there, ex is still around, involved with the children. Some parents can actually be as close or closer to their stepchildren than they are actually to their biological children. And those of you who have an historical memory might recall one of the lines from, I believe, the first episode of the Brady Bunch. The only steps in this house are the ones leading upstairs. So every child treated equally, every child loved equally. And I have seen these dynamics among my clients. Marriage, remarriage, the blended family can be very harmonious. Here's a fine example of harmony in remarriage. You might recall The Sound of Music, lovely film. And Maria is the second spouse who comes in and takes over charge of all of the children, the Admiral's children. So remarriage can be a beautiful, harmonious thing. And we want to help you make it that way with regard to your estate planning. Another type of blended family dynamic is the younger spouse, or you could say the older spouse. Here's one of my favorite folks. Since I grew up with Star Wars, I've always appreciated Harrison Ford. So I had a toy Han Solo and a Millennium Falcon when I was a kid, and I love those things. Thank you, Mom and Dad, by the way. So Harrison Ford's wife, Callista Flockhart, is nearly the same age as Harrison Ford's oldest child, born in 1966. So situations like this require planning, right? Estate planning, because you don't want your children who are the same age as your spouse to have to wait until the spouse dies before they can inherit anything. That might not be a good dynamic to leave to your spouse and your children. So Harrison Ford is not one of our clients, by the way, although I'd be very happy to see him in the office. So blended family dynamics, sometimes you have folks remarrying in later years, in this case, both members of the couple. So this is happening with some regularity. Not too long ago, I had in my office someone who has remarried. Both of the pair are in their 80s, and they needed to redo their estate plan before we even gave this webinar. Very forward-thinking folks. So when couples marry later in years, the children may actually be grown and gone. And what is the relationship with them? There might be no relationship with them. Relationships with the children and the stepchildren may be strained. They may be harmonious. We have no idea until we sit down and we talk to our clients. But you know what your family is like, and you know how you want to provide for them. And all these types of relationships we want to take into consideration when reviewing your estate plan and considering your options. So what are those options for blended families? How to plan for your blended family? So ideally, you're going to start planning before you marry or remarry in this case. So discuss property and inheritance with your spouse-to-be. That's one of those things that you probably want to be thinking on the same page about. So discuss that estate plan, discuss property, and consider a premarital or a prenuptial agreement. Now, these premarital or prenuptial agreements, they're not only for instances where spouses do not trust each other. They really aren't. They can be very useful when you have different sets of children, for example. And it is essential, if you do reach those agreements, to actually integrate them with your estate plan, and then to avoid unintended consequences of loosely handling your assets, such as mingling separate property so that it actually becomes community property, or hard to trace to decide what's separate and what's community. And you want to sit down also with your spouse-to-be and determine new priorities for your blended family. Many of the clients that I have that are in this situation, they love each other and they want to provide for each other. So the first one to die wants to be sure that the survivor is taken care of. On the other hand, some of them want to be sure that their children from a previous union are not disinherited. So they want to protect the inheritance rights of those children. And some of them have children themselves. So they'll have children from different unions, and then they'll have joint children, and they want to provide for those as well. You need to sit down and you need to determine what your priorities are. And you really should discuss this before the marriage so you can start your planning then. And then on the honeymoon, here's an estate planning checklist for your honeymoon. This is romance redefined by an estate planning lawyer. So you'll have to pardon me for coming from that perspective on everything, but that's my job right now. We review, first of all, you want to review your payable on death designation. So you've been having a great day on your honeymoon out in the tropics, you've been in the beach having some margaritas. What thing to do more romantic than come back to the room, break out the laptop, and make each other your payable on death beneficiaries? Nothing stokes romance like that. So first of all, you can do many of these things online. You can change your IRAs. You can change your 401k payable on death beneficiaries. If you're married, spouse is the natural best, really, person to inherit those qualified retirement accounts. They can stretch them out for their lifetime. Life insurance policies, sometimes you can change those payable on death beneficiary designations online. Sometimes you just get the process rolling. But be sure that your spouse, if this is what you want, and what you've decided is your payable on death beneficiary for life accounts and for life insurance and for bank accounts that transfer that way. Do not, as George Clooney in the movie Intolerable Cruelty, some of you may remember, he brought his prenuptial agreement to the marital chamber and tore it up in his joy at being married. I don't recommend that you bring the prenuptial agreement on the honeymoon, but that might be a good time to start thinking about scheduling an appointment with your estate planning attorney to make sure that your new marriage is on a solid foundation. Keeping it separate, the joint pour-over trust. Okay, so these are a couple options. Now we're talking about trust options, and I'm only scratching the surface here with a couple types of things that blended families will do in order to provide for each other. So the spouses are providing for each other and for their children. So one of these options is what we call the joint pour-over trust. So this is an option when married clients have different beneficiaries in mind. So they want to give their assets to different sides of the family. It works best in conjunction with premarital agreements and with carefully keeping everything separate. And it basically creates three trusts. So there's a joint pour-over trust, that's for community property. Remember that distinction. And then you have separate property trusts for each spouse. So 2 separate property trusts plus the joint pour-over for the community property. So that joint pour-over will actually terminate when the first spouse dies. And then the first spouses, then both community property assets get divided between the separate property trusts. And then what you have are 2 separate property trusts. Each of those will go in, can be different options, but in the end, they go to the beneficiaries named by the different spouses. So let's say that each spouse has children from previous unions, and each spouse's separate property trust goes to their own separate children. Another option, well, this is the same option. Actually, we're going to call it the Brady Bunch plan, and I'm going to give an example here. Mike has 3 children. Carol has 3 children. Mike marries Carol. Mike wants to leave the Arizona cabin he inherited from his family to his children. Carol wants to leave her family's Orange County beach property to her children. They want to leave their Los Angeles home to each other. You might recall in the Brady Bunch that Mike was an architect. He designed the Los Angeles home in which they lived. So they prepare a joint pour-over trust and 2 separate property trusts, ensuring that they provide for each other. They want to make sure that the survivor gets to stay in the Los Angeles home, but they want to make sure that their separate family properties go to their children. So Mike's Arizona cabin through his separate property trust goes to Mike's children. Carol's Orange County beach property through her separate property trust goes to her children. Now here's another option. Again, we're only scratching the surface here, and we can there are a lot of variations on these themes, depending on the details of your own and dynamics of your own blended family. So one joint trust with a split. That's where the split divides after the first spouse dies. Now, in many instances, trust splits are no longer necessary for tax purposes. They were used a lot for tax purposes before there were a couple changes in the law, which we needn't address now. But those splits can be used to prevent your surviving spouse from disinheriting your children, because sometimes that's a concern. How does that work? Okay, so spouse B dies. And when we say A and B, if you think buried spouse, alive spouse, that might help you keep this straight. So spouse B dies. Spouse B's separate property and half of community property goes to the B trust. So the single trust split after spouse B dies. The buried spouse is out of the picture, but now you have a trust split. The B trust, the A trust. Spouse A lives on the A trust and on the income from the B trust. Let's say, for example, that the B trust includes Tesla stock. Good investment. And the B trust, right now, anyway, with gas prices going up, it's a very good investment. It's going up. So the B trust then, that income and dividends from the B trust is going to the survivor, helping the survivor live comfortably. And in the meantime, when the survivor, when spouse A dies, the remainder of that B trust goes to spouse B's children. So spouse B prevented a situation in which spouse A could disinherit spouse B's children. I think we need an example to understand this a little better. Harold and Holly remarried later in life, and each wants to leave property to their children from previous marriages. Holly is in poor health. She wants to take care of Harold if she dies first. However, Holly is concerned that Harold will remarry and disinherit Holly's children. We did note this statistic that men are more likely to remarry than women, and a lot of women feel this. We do experience this with our clients. They're concerned that, shortly after the funeral, their spouse is going to run out and marry again. So Holly and Harold create a joint trust with a split. When Holly dies, her property goes into a B trust that Harold cannot change. He can't change that B trust. Harold benefits from the income of the B trust, let's say it's Tesla stock, while he is alive. And when he dies, the property in the B trust goes to Holly's children. So Holly accomplished two goals. She made sure that her husband would be taken care of, and she made sure that her children wouldn't be disinherited. Well done, Holly. That's a good plan. Also, blended family dynamics will entail leveraging non-probate assets. We've mentioned non-probate assets several times during the course of this webinar, and right now, we're going to think about how they might actually be applied in a situation in which you have the older spouse, younger spouse. So Hale is 20 years older than his second wife, Wanda. Hale wants to leave his house and enough of his cash and investments to Wanda so she can live comfortably for years after his passing. But Hale doesn't want his 3 children from his first marriage to be disinherited or to receive nothing while Wanda lives. That's a long time to wait. And if your father's spouse is your age, you might die before your father's spouse, so no inheritance in some schemes. So what can Hale leave to his children immediately upon his death? Well, there is the possibility of those qualified retirement accounts, although he'll need Wanda's permission to do that because they should go to the spouse first. Life insurance policies are another option. Certainly, life insurance can be a way to provide for your children from a different union as soon as you pass. And also those payable on death accounts. Perhaps Hale has some certain payable on death accounts with funds in them that he has go right to his children immediately upon his passing. So estate planning for your blended family includes not only the right kind of trust, but also leveraging those non-probate assets. And when we meet with our clients, we actually ask them to fill out a questionnaire. This questionnaire seems to some, why am I giving you all this information? This is too much information. Well, because we need to know about things like these. They all need to be taken into account when you're preparing your estate plan, because you want it to be one whole integrated plan. That is the end of the presentation. And let me see if I have some questions here. And Q&A. I'm looking at them now. I understood a trust is made by both spouses. So how can the wife not obtain benefits if the husband dies? Is that the same if the wife dies? Does the husband then not gain those benefits of the trust after a divorce also? Okay, that's a lot of questions. Let me back up and answer them one at a time. Yes, trust can be made by both spouses, but you can have separate trusts too. So spouses can make separate property trusts that handle only their separate property. The wife may or may not obtain from the benefits after the husband dies. It depends on how the trust is set up. Now, usually that's the way it's set up. That's the way most of our clients want to do it. That's the way we would typically recommend it. But sometimes they have separate property assets and they want to keep everything separate. And that can happen. Yeah, it can go either way, whether husband dies first, wife dies first, the trust can provide however you want to address those issues. And you can have different provisions if one spouse dies first. I've seen that too. Does the husband then not gain those benefits of the trust after a divorce also? Well, we did mention that divorce will change your estate plan. So certainly divorce changes your estate plan and it changes your trust. So your trust assets are going to be taken into consideration when you're going through a divorce, and somehow or other they will be addressed. If they're not, that's an issue that does need to be addressed, but typically they're discussed in the order, just like all the other property of the marital communion. And I do not see any other questions. So it has been a pleasure speaking with you today. Do not forget to subscribe to our YouTube channel. We have a lot of educational videos on these matters and similar ones. We have soon coming up an entire webinar that will be on divorce and its impact on your estate plan, closely related to this one. And if you do enjoy our webinars, then please review us on Google. Thank you very much.